Alan Stephan.
Morning. Please be seated. This is the time set for oral argument in Kelly versus Kelly, our cause number 1CA CV20-441FC. Council courtroom looks a little different than it has in the past. We're all distanced up here and have removed our masks. People in the courtroom are free to do so if they wish. Each side has 20 minutes for oral argument, and if the appellant's ready, you may begin.
Your Honors, may it please the Court, Daniel Beeks on behalf of the appellant and cross-appellee Garrett Kelly. As this Court knows, in Hayes v. Gama, the year the Supreme Court held that when a trial court in a family law case is considering legal decision-making and parenting time, it shouldn't enter a sanction that precludes evidence regarding the best interests of the child, unless lesser sanctions have been first explored, proven to be unsuccessful, or just a flat out.
I'm not even sure the court in Hayes said unless. I remember when Hayes came out and I was a trial judge assigned to the family court division, I was fairly well outraged. I didn't see any unless.
Well, they did cite to a Texas case.
That doesn't constitute an unless when the Arizona Supreme Court has spoken.
Well, I like your interpretation even better than what I'm arguing. You just flat out can't do it. And I agree that in this case, that rule should apply. And even if it could do it, it could only be done as a last resort after first trying lesser sanctions. I think we could probably go back and forth about whether it was allowed, because they did talk about in Hayes versus Gama that monetary sanctions or community service could have protected the court's authority in those issues.
But doesn't this court affirm suppression in Johnson versus Port? I can't say it.
Neither can I, and I'm glad you stumbled, so I don't like unphone when it comes out. Johnson, I call it pro voyeur, but probably
it works for me.
Yes, he did, but that's an easy case to distinguish. Johnson certainly cited the Hayes and said you were required to admit it unless, in this case, and the reason it didn't, is the evidence that they were excluding had very little practical effect on what was going to be going on. As you recall, in Johnson versus Provier, the trial court had excluded a supplemental report from an expert witness. They admitted the actual expert's original report and then excluded the supplemental report because it came in the last 60 days. The court found that supplemental report wasn't at all very interesting or very helpful because, number one, it primarily talked about the opinions of what the children wanted, and the court found that the children weren't of sufficient, of suitable age and discretion that their opinions should be given much weight, and that the original report provided the court with adequate evidence of the children's best interests. The distinction between Johnson versus Provier in this case is the court totally excluded all father's evidence, including even allowing father to cross-examine mother about her own testimony. So, and quite frankly, Johnson Provier is a court of appeals case. It can't overrule the Supreme Court case.
Well, I don't think it purported to. I don't think Johnson purported to overrule Hayes. So you have Hayes that says you can't exclude evidence bearing on the best interest. What was the proffer?
In our case?
Mm-hmm.
Well, the proffer, was there enough, if you're talking about an offer of proof, there was no offer of proof per se.
Is that a problem?
No, not at all. The case law that Mother cites in her brief dealing with the offer of proof issue, as we said in our reply brief, it cites to the Livermore and Udall treatise on evidence, and the Livermore and Udall treatise makes it clear that an offer of proof is not required if the subject of the evidence is apparent, and number two, the court has issued a broad order precluding all evidence on it. That's exactly what we have here. Father had filed a motion for temporary orders that included all the evidence. He filed this 19-page memorandum that was pending, outlining all of his evidence against Mother. So the court was well aware of what the evidence was, and the court had issued a very broad order precluding Father from presenting any evidence that could have been presented to the CFE provider.
But counsel, let's say the court was not aware. Wouldn't your argument be just as strong that the court is excluding an unknown universe of evidence that might or might not depend upon, because the court hasn't looked at it, bear upon the child's best interest?
Oh, I think even if the court hadn't read the motion for temporary orders, hadn't read the 19-page memo that's been filed, you're right. The court still erred in excluding highly relevant evidence regarding the children's best interest from one of the two most important witnesses there would be, from the father.
But you're saying, though, that the court did know what the evidence would be.
Oh, yeah. I mean, there'd been a motion for temporary orders that had been withdrawn basically at the last minute that detailed all of this. There was a half-brief motion to disqualify the CFE provider that recited in long detail all of the evidence the father would have presented. So the court was certainly aware of what father's evidence would be, and there was no need for a formal offer of proof. And quite frankly, as we stated in our brief, I think it's Rule 103 of the Rules of Evidence says that after the court has made a definitive ruling, you're not required to renew your objection at the time of trial or make an offer of proof. So in this case, I'll admit the father's attorney did not make an offer of proof at the time of trial, but it doesn't matter if it wasn't required.
So what consequences should have befallen your client?
The court should have explored lesser sanctions. The court should have tried, for example, imposing community service. The court should have perhaps imposed monetary sanctions. That's what the
How about
court
incarceration?
Said you should try.
How about incarceration for civil contempt?
That is certainly one of the arrows in the quiver, I would say.
Your client's okay with that? Because your client's conduct is, I mean, it's a really good thing that Hayes v. Gamma exists because it gives you something to argue. Otherwise, I don't see what the argument would be.
Well, the argument in the hypothetical world is he was entitled to a hearing to see if he was acting willfully or in bad faith.
Right.
You think he was acting negligently or in good faith?
Right. I mean, go ahead.
Actually, let me call who's going to answer what, okay?
Sure.
I know you'd rather answer Judge Weinswag, but why don't you take my question first?
Okay. So your question is, should we have had a hearing? What would the argument have been? The argument would have been, there is a motion pending to disqualify the CFE provider, Julie Cocoon, based on mother's attorney engaging in ex parte contact with Ms. Cocoon in violation of the court order. And there was other parts of the motion as well.
And Dr. Weinstock, any argument on that?
Dr. Weinstock had withdrawn because Dr. Weinstock himself screwed up. Yes, there was an issue early on with my client saying, hey, I want to make sure my side of the story is considered in the CFE, at which point the trial judge said, okay, then fine, you're going to participate, you're going to pay half. Then there was an issue with whether or not my client was able to submit some paperwork in time.
Did he submit any of the paperwork ever?
Yes, he fumbled with Dr. Weinstock's document portal, which other clients I've had that problem.
So let me ask, we'll go to the due process point.
Okay.
What would the hearing have, so from what I can see, this order used less than definitive language, and it talks about a communication with Skatoon documenting. Was your client, I think you are arguing that your client never received that document, so what would the hearing have even been about?
Whether my client, as the trial judge said, the update from the CFE provider stated, it appeared, and I don't know exactly.
Right, but did you get the
appears
update?
is the language. The father is not cooperating in
Right, your client never received that update.
He did. The update is not in the record. subsequently received or tracked down. I don't remember.
How subsequently?
Late, but there is a copy of it somewhere floating around,
Okay.
but it's not in the record, and I didn't bring it to me. But that's not my document in the record. What would the hearing have gone to? Whether my client was or was not acting willfully or in bad faith in not participating with the CFE process with Julie Skiffoon. And given the fact that there was a half-brief motion to vacate the appointment of Julie Skiffoon based on mother's attorney allegedly engaging in ex parte communications with the CFE provider in violation of the court's appointment order,
Right.
There would have been a very good reason for my client to hold off on incurring the fees of going through that whole process until we figured out whether Julie Skiffoon was going to be the third CFE provider.
Well, I'm going to go back to what Judge Swan asked you. Given the history of this case, is there really a question that he was not cooperating with the appointment of these experts?
Sure. Let's start with Dr. Weinstock. That's the easiest one. There was an issue early on about whether he was going to get his side heard. And the judge said, yep, you're going to get your side heard, you're going to pay half. That was step one. Then there was step two, there was some problems getting some documents through Dr. Weinstock's court. When Dr. Weinstock finally got off the case, he himself asked to be recused. Why? Because Dr. Weinstock had screwed up. He had provided mother's attorney with some intake forms from my client that the judge had said, don't give those. The intake forms shouldn't be shared with the other party's attorneys. And when Dr. Weinstock dropped the ball, screwed up, whatever you want to call it, and did that, my client objected, and Dr. Weinstock said, you've got an issue with me now because I've screwed up. I think it would be better if I withdrew. And the trial court allowed him to recuse himself. Did not discharge him because my client was not cooperating. Discharged him because he asked to be recused because he
So this whole chain of events, going through two evaluators and finally resulting in these sanctions, your client was just innocent. It was a comedy of errors playing out before him, and he was doing his best. Is that your position?
Pure as the driven snow.
No litigants are pure as the driven snow, especially in family law. You guys have been on it. You know that. Was he pure as the driven snow? No. Was he
even arguably compliant with any part of this process?
Oh, yeah. Yeah. He was. And quite frankly, what matters is what's in the record. And what's more important is what's not in the record, because we didn't have a hearing to find out what happened with Julie Skiffoon and what didn't happen with Julie Skiffoon. Julie Skiffoon sent some sort of update to the trial judge indicating a lack of cooperation, no notice, no hearing, no opportunity to present evidence that he was cooperating. The judge said, that's it, you're not presenting any evidence.
Okay, so did you get that update before the order, after the order? That was my question, is when I was saying, what is there to have a hearing over, it would be over the content of the update. But if your client didn't receive the update, but now I understand he did.
He received it, but even if he did, the CFE provider isn't the judge who gets to decide whether or not he's acting in good faith, in bad faith.
Well, we don't know what the update said. How do we know that's what the update said? It just said, what it said. I received an update documenting, these very general terms.
Right. And so what's the court required to do under the case law? Have a hearing to figure out if he's acting willfully or in bad faith. It didn't do that. It didn't give him the opportunity. It just slapped him upside the head and said, you're done, you're not presenting any evidence.
Maybe, given the time, if you have other issues you want to address, you should turn to those.
Well, they're all pretty well briefed. The other reason, primarily.
And I have another question. Where is it that says what this universe of evidence was that was excluded? I mean, if you look at the documents, I think Mother had like 62 exhibits that were admitted, and your client had 4. Where can I look at that list or discern? Because the way I read the briefs was it was just sort of excluding an undefined, boundless group of evidence that might or might not have been, directly bearing on a child's best interest.
So if you look, and I could thumb through it, but what I would tell you is, look at my reply brief in the section dealing with whether or not we need to make an offer of proof. And in that section, I cited to the record on appeal all of the documents my client had already filed detailing the positions he would have testified to had he not been prohibited from doing so.
Yeah, and I'm not so concerned with the offer of proof argument, because Hayes talks about the duty of the court, right, to look at the evidence. But that's a different story if the court, when it made this order excluding everything you could have provided to Skatoon, knew what it was. Now, it might still bear upon a child's best interest, but it's not just a penalty without, tethered to facts, names, numbers, colors.
There is no formal, my client's trial counsel didn't stand up and make an extensive offer of proof and saying, if my client was allowed to testify, here's what he testified, and go on and on for half an hour. Didn't make that kind of an offer of proof. But it was all in the record at the time the judge had issued the preclusion order back after Skatoon had sent in the update. I got 4 minutes left. If you want, I can keep going down this path. My other argument primarily deals with Dr. Corsten and her testimony, and her report should not have been admissible. That's fairly simple. Rule 702. But number one, my client had filed a notice invoking strict evidence under the Rules of Family Law Procedure. We all know what that entails. My client's attorney had filed a motion to eliminate to preclude Dr. Corsten under Rule 702. Rule 702 requires basically three things. Number one, testimony would be helpful. Number two, that's based on sufficient facts and data. And number three, that's based on reliable methodology. None of those three applied in this case. When the trial judge dismissed Skatoon, she said a one-sided report from a mental health expert wouldn't be helpful. So it's not helpful. There's no reason to have Dr. Corsten testify then. Number two, at her deposition, Dr. Corsten herself testified she did not have sufficient data and information required by the standard of care for mental health professionals to render any opinions on legal decision-making or parenting time. Also, she testified, number three, she hadn't applied the required methodologies and procedures for analyzing the evidence. And number four, probably most importantly, ethically, she was prohibited from providing any opinions about legal decision-making or parenting time. That being the case, her opinions should never have been admitted. The report, which Mother's Counsel argues could have in theory been admissible to serve as the basis for those opinions. There's no opinions. The basis becomes inadmissible anyway, and the backup document is the basis, never becomes substantive evidence in and of itself. It's only admitted for the basis of the expert's opinion. Shouldn't have been admitted in the first place. I'm going to save my last 2 minutes because I've got a little bit to say on some of the cross-appeal issues unless anybody else has any questions.
Thank you.
May it please the court, Keith Berkshire and Kristen Kelly, the applicant in this matter. Obviously, the main issue is the sanctions imposed here and whether they comply with Hayes v. Gamma. And like Judge McBurney stated, I think the real test here isn't this single isolated incident where most likely Julie Skatoon sent an email said father is not, cooperating with his documents, that the court then entered the final order. It had looked at in isolation, maybe that would violate Hayes v. Gamma. But that
what about, let's divorce it from the due process issue. Are you saying that the court did not exclude any evidence bearing on the child's best interest?
Well, assumably it had to. If it prevented one of the parties from entering evidence, it would.
Okay, and how does that relate to Hayes?
Well, Hayes isn't an absolute preclusion that you can do whatever you want through the history of the case, act as badly as you can, and ignore every court order, which was, there were hearings here. There were multiple hearings here repeatedly over the course of months. That isn't the standard of Hayes, is do whatever you want and show up, ignore all discovery, never answer, don't show up to a deposition, don't.
But let's focus on the other end, counsel, of what's being excluded. Are you saying that a total evidentiary sanction is appropriate in some situations as to do with the child's best interest?
Of course, it has to be. You can't have a party that does, let's say they never answered discovery questions, didn't show up to a deposition, didn't participate in anything, that then just gets to come and tell their side of the story at trial. The other side has a due process case too.
But isn't
Mom
that...
has due process rights too, and she has a right to present her evidence and right to get evidence during the course of the case.
But discovery is not a matter of due process. The use of third-party providers to do the court's job for it is certainly not a matter of due process. So I'm really struggling to see how Hayes squares with your position here. As I said before, I remember when Hayes came out, and as a trial judge, I was deeply troubled. As I've aged, I've started to see the wisdom of Hayes. But what is clear is that it was written with a very thick pen. And I don't see an exception in Hayes that allows this kind of sanction. As I suggested before, jailing father for civil contempt might have been available. But exclusion of evidence that relate to the best interests of a child seems not to be. It seems to me that the Supreme Court basically stepped back and subordinated the interests of the integrity of the court to the interests of children.
Well, the statute does, but...
Well, again, so
if you disagree with that reading, and it seems you must inherently in your position, I'd love to hear the language from Hayes that gets us there.
Again, I think that the issue is the process. Husband had an ability to present his evidence. In this case, with mental health evaluation as being implicitly part of a CFE, that's one of the reasons the court ordered it. I want you to participate in this. I think the evidence is relevant because of all of the factors of 25403A in that this professional can do part of it being an evaluation, and he's precluding that. So I guess...
Well, but that elevates the status of the professional to a point far beyond what the statutes contemplate. It's no secret that I've been a little uncomfortable with the way trial judges sometimes farm out their work to high-paid professionals. But whether the rules allow that or not, what is clear in both our case law and our statutes is that the court has the ability to make the decision based on evidence in the record. And delegation of that responsibility to a third-party professional is not permitted.
Well, but I believe it is. I mean, even in the Supreme Court case, Pauly, the Supreme Court came back and said, we use these for evaluative purposes. That's what the court did. That's what the court did here. And in Pauly, they specifically stated that the purpose of 25405 was for evaluations, and the court has the right to do that for an evaluation purpose. That's what the court did. They said this evaluation is necessary for the court because there are areas that are outside the expertise of the judge that might require some specific knowledge, and that's what the custody evaluation here was meant to do. And by not allowing that evaluation to go forward, that was the issue.
Well, but that might explain why the evaluation is relevant and admissible. It doesn't substitute, though, for the court. The delegation is not permitted, even under Pauly, unless I'm misreading it.
I don't disagree. I'm saying
Okay.
that the statute makes it absolutely relevant.
Sure.
From the standpoint, the same as the statutory factors under 25403A make relevant mental health and other actions in this court that the evaluation was intended to do.
So it may well be that by being non-compliant, father casts such a pall on the evidence that he might present that he loses. I'm not saying that this conduct doesn't affect the merits. What I'm saying is that Hayes v. Gamma seems to stand as an absolute bar to this kind of sanction. And if you have a way of interpreting Hayes otherwise, I'd be very interested.
Well, I think the issue is, okay, the lesser included sanctions here. How many times does the trial court have to do it? I mean, is there a list of 75 lesser included sanctions that I have to go one by one?
So I don't like the word lesser. And let's define the sanction at issue in Hayes. It's an evidentiary sanction that impacts or that excludes evidence of a child's best interest. Every other sanction is on the table. So whether you want to call incarceration lesser or greater, the point is the quality of the actual sanction here. And so where in Gamma or anywhere does it say the court can use a parent's intransigence against or to not harm necessarily, but impact the child's best interest? Where does it say that you can do that?
When this court has interpreted Hayes v. Gamma a couple times related to experts and so forth, they said allowing for continuances, other things would be allowed, allowing the monetary sanctions would be allowed. There's never been, I mean, I understand the reading of Hayes, but Hayes can't be read to say no matter your behavior, that you always get to testify in a family court case. That no matter what you do, you don't show up for a deposition, the other side doesn't have a right to present evidence, you don't have the other side doesn't have a right to litigate their case.
Well, this was much broader. It wasn't just testify. It was no evidence. He wasn't able to ask the questions of the opposing witnesses, right?
And again, I think that the point here is that he was given multiple opportunities.
Well,
and the court found that these continuances were the opportunities that.
Okay, his behavior may be deplorable. Was there no other sanction available? Did Judge Marwell have any other sanction available when she got Julius Cocoon's note?
I don't know if there's a non-exhaustive list of sanctions that.
Can you come up with one? Because I can. I can come up with a lot.
Well, you could say, I mean, I guess you could come up with monetary, you could come up with jail. But since he hadn't complied with any of those already, was there some reason to believe that he was going to do it here?
I've found jail to be very effective.
I've never been there, but I
No, but I've used it. I've used it as a contempt sanction, and it turns out it works every time.
Again,
I've had them show up and testify in front of me in jailhouse. Garb. So I've used it
that
as
would
well.
indicate that in jail wouldn't be effective.
Oh, he testified.
But I'm saying if you send them to jail and they stayed there to do it, again, I mean, it comes down to how many opportunities can they get. Did Judge Marwell think that this was the appropriate sanction in her discretion of saying, hey, I've had 4 or 5 hearings, he's claiming that, mom's lawyer's a criminal and that this is why. I mean, the actual record on this, if you read is pleadings. I mean, it's.
But the most important thing, I think, is you're missing sight of the fact that we didn't get a two-sided version of what happened or what was in the child's best interest. We only got mother's version. And how can a judge make that determination without getting something that would balance it out?
I think that the behavior is what, again.
So punishment to the other parent is more important than making a valid best interest determination under the statute. Is that what you're saying, Mr. Berkshire?
I'm not going that far.
Well, that's what I'm hearing.
But I'm saying that there is a procedural point at which any parent should not be able to participate if they are violating the fundamental due process rights of the other party to litigate their case. Both parties have a right to be heard. And if mom can't get her own evidence in because he doesn't participate, won't answer discovery, won't do anything else, at some point her due process rights mean something.
Well, why can't mom just give her evidence to the court?
In this case, they believed that the mental health evaluation was necessary, and that mental health evaluation by an expert that they believed was a necessary factor here, and the only person that could do that would be an expert. I mean, we've got cases like Bell and so forth that I understand.
Well, not everybody. I mean, I question that it was necessary. The court seemed to find a lot of third-party services necessary. I don't see why you need a special master to figure out the later issues. But if these people had had no money, would it have been necessary? Or would the court have just said, oh, you can't get divorced?
I mean, there are, I guess there's avenues through conciliation services that do CAAs that do.
There sure are. And there's a trial in front of a judge, failing all else, when experts are not available. Special masters are a luxury. Maybe that's too kind a way to put them from the standpoint of a party paying the bill. But the vast majority of litigants in family court can't afford any of this stuff. So to say it was necessary seems a stretch to me.
Well, again, under the circumstances, and again, both parties essentially agreed to it. If you read, in our brief, we go through this history of events here where husband agreed to participate, husband agreed to give the documents to Weinstock. As long as his concerns were heard, he agreed to it. So it's not like he was opposing this from that standpoint on any monetary thing. So the parties both agreed to the process. And
I'm not disputing that the court had the ability to appoint the expert. What I'm concerned with is the interpretation of Hayes. You say Hayes can't be read to have the effect of taking this sanction off the table, but I think that's why Hayes was written. And I would just for clarity point out that I think there are two means of analyzing potentially dispositive sanctions. One is the Zimmerman line of cases that deals with progressive sanctions and lesser sanctions. I don't think Hayes concerns itself with lesser at all. And I think for a lot of people, jail would be considered worse than the inability to submit a document. So I don't think this is a question of lesser or greater. I think it's a question of whether Hayes took the preclusive sanction off the table. And we get back to, if you believe it did not, can you please point to some language?
Well, I think you have to point to the facts of Hayes. This was just, you did wrong, you took the wrong counsel, we're not going to let you do it. It wasn't ever meant as a sanction for non-compliance with the process. It was just, hey, I said, in Hayes, the fact was you took into account so that we said that other than the one, it was clearly relevant, clearly timely, those types of things. The issue of actually it as a ongoing discovery sanction for failure to cooperate in the process wasn't what Hayes was.
So let's recognize, because it seems like we're blending what could be regarded as three separate parties with interests of their own. Would you acknowledge that the child has a right to have a custody determination made in her best interest, aside from the parents, almost as if they're bit players?
Absolutely.
Okay, so if we focus on that, how does your argument work?
Well, my argument works because there's two sides to the evidence being presented in this case, and it gets into one of our cross-appeal issues. That if mother is precluded by father's actions from getting the evidence she needs, the mental health evidence she needs, this is the first issue in our cross-appeal, if she's prevented because of his actions, then doesn't the child have the right to have the evidence presented that mother wants if father would have complied? Doesn't the court require it statutorily based on the legislative discretion or legislative mandate in 25-40385 that mental health is relevant? Isn't his preclusion of that by not cooperating, doesn't that also impact the child in the same way as his testimony? I mean, you're looking at what he didn't get to present, but not looking at what she didn't get to present. She didn't get to present the evidence.
Well, but no, that goes exactly to what we're talking about, and that's the notion that the trial court picked a sanction that didn't move the ball forward. The trial court picked a sanction excluding his evidence, but didn't pick a sanction that would have gotten the information you want on the process.
Well, but it assumes he would have done it.
And the error occurred at that first instance, where you have, you might have an argument as well, but that's not, the first issue here is that father presented 3 exhibits and was prevented from asking questions and introducing witnesses. Whether or not your client was also deprived of a like opportunity, I don't know how that defeats the error in the first instance.
But it wasn't mother's actions that ever did any of this. I think, again, to read Hayes outside of the facts of Hayes, I get that the Supreme Court goes and makes grand statements of law, and I'm not saying that it's incorrect, but at some point, Hayes can't mean no matter what you do during a case, you always get to introduce your evidence.
Why not?
I come to court the day of trial with 15 banker's boxes of stuff that have never been disclosed except for 3 minutes prior. Hayes can't stand for that. Hayes can't stand for absolute trial by surprise or things like that. And
wait a minute. Yeah, sure, Ken.
What kind of case?
Because you show up, you say, here are my exhibits. We hear everything, and then I turn to the other side and I say, okay, do you need some time? Because if you do, I'm going to grant a continuance, and now you know what all of your evidence is. Now Unless you're saying, oh no, I have an absolute right to present that at that very moment in time, and continuances aren't a viable option.
But this was continued multiple times already because of the non-compliance with the evaluation. The court did that, and there was still non-compliance with the underlying order. Again, this wasn't an order just against Dad. This was an order against Mom, too. The final order in this case, I think it was July 2nd, said, if either of you don't do this, I'm going to preclude it. It was that this is necessary, or the court, this judge thought it was necessary for the eval, and did this. Again, it was after multiple hearings. I get that they didn't get a hearing on the sanction. They had multiple times to comply with this. And it wasn't just one first RMC, haha, you didn't do it. I'm sanctioning you, you can't do it. And the court found that this was the appropriate limitation, and it didn't go so far as to default him. I mean, the court stated that they thought this was actually one of the lesser sanctions.
Can I move you on, since you only have 2 minutes? On your notice of appeal argument and the Franklin Templeton account.
Quadro.
Right. What can you explain that?
Well, his actual and for the Quadro, clearly the parties, if you look at their pretrial statements, both agree to a special master to determine the community interest. The determine the community interest absolutely implicates whether funds put in or withdrawn were community. That's the idea of a special master in Quadros, which this is sent out. I mean, perhaps the most common use of special masters is send it to a Quadro attorney, because those attorneys, I mean, frankly, it's the reason we all do it is we don't want the malpractice, and those people have access to the forms that each of these the financial institutions use, because they use the same forms all the time. And why none of the family law lawyers really do them, and there's 8 people in town that do all of them, because I don't want to cover the malpractice on them. But it was sent there by agreement. Again, father didn't participate. He could have taken the information to this person and stated that. What he's objecting to, what he's really appealing, isn't the appointment. He's appealing the result of the appointment, which he didn't file a notice of appeal for the final order in this case, which was actually the court adopting the special master's ruling. He appealed, and I pointed out the 3 dates that he filed, or 3 minutes that he appealed, but this one wasn't appealed. Their counter to this is, well, I appealed the appointment that stated that it should be the $32,000. That wouldn't have even been the final order. So, I mean, again, he had a right to participate. He chose not to. He knew the issue. He knew what was being appointed. He chose not to participate. I don't think it was a timely appeal, especially in the land of the E case from this court. I'm not sure what the final appeal on that, or a final order subject to. It wasn't final. His notice of appeal was not filed after the final order, which was the court adopting the special master ruling.
Right. He appealed the decree.
He appealed the decree, which was appointed, not even the appointment of the special master. The special master hadn't done anything yet. And again, the special master in the report said he didn't participate. He was invited to participate. Didn't do it. He didn't present any evidence about whether this $65,000 was withdrawn. Therefore, the special master ruled as they saw fit. So one last one in my last 20 seconds on the domestic violence. We think the court, if you look at the standard the court used in the back and forth between Ms. Swiren and the court, that it clearly was applying an incorrect standard for domestic violence, that substantial somehow meant you had to have a police report. It also ignores the Luna v. Pettit case out of this court, which is for parenting time, not decision making. That if you find any domestic violence, you have the presumption, and this court went through that pretty well. And I think that was a misapplication of the standard for DV.
Thank you.
I'll try to do it quickly and maybe in reverse order. We'll start with the domestic violence issue. As we argued in our brief, it's pretty much removed anyway. The significance of domestic violence only goes to the issue of legal decision-making. Mom got sold legal decision-making anyway, so regardless, it wouldn't change anything in the outcome. Yes, I agree that the fact that she didn't make a police report or get an order of protection isn't determinative, but is it relevant evidence as to whether or not Mom believed that it was significant? Yes, it was evidence the trial court was entitled to consider. Let's talk then quickly about the cross appeal, whether the trial court was able to condition father's parenting time on getting a psychological evaluation, number one. Mom never requested an independent psychological evaluation after after the CFE provider was discharged, they knew one wasn't going to take place. If they wanted one, they should have asked for one. They didn't. They waived it. We've got somewhat an unusual situation, the Jorgensen versus Giancini case that got decided after I filed my response brief, before they filed their reply brief. The case says what it says. You can read it, take it with a grain of salt. Father didn't even file a brief on it, so the quality of the advocacy and a number of the decision of the suspect. But put it all aside, the defining point in this case is Judge Marvel found father had committed domestic violence. ARS 25403-03F says once you've found domestic violence, the court can put conditions on parenting time. So that statute allowed the conditioning of parenting time on psych evaluation. Back in 1970. Does anybody have any questions? Otherwise, I'm not going to get any more than another argument.
You do recognize that if your position on Hayes is correct, that the court can take the course of conduct into account in credibility assessments and other ways that might affect the merits of the case. Would you dispute that?
Oh, once we get back to the trial court, yes, without a doubt. That's
okay.
Something they can take account of, like every other.
Well, thank you. And thanks to both counsel for their arguments. This matter is now under advisement, and we will issue a written decision in due course. The court will now stand in recess to allow the next case to set up. Thank you.